Ready? Start. The order of suspension was passed on 17/10/1988. It is not necessary to go into the question as to why the suspension order was not served for 3 months, but the malafide should be inferred by reasons of the fact the order of suspension was passed and that in collateral proceedings the said suspension order has been set aside or revoked is wholly irrelevant. Full facts are not available on the record of this case regarding the other proceedings which had taken place with regard to the passing of the suspension order, the same being set aside, or with regard to the order to transfer which was passed. What is, however, important is that the order of suspension was passed against the respondent, who was a police officer, after the filing of the first information report in the present case. A prima facie opinion had been formed that the provisions of Section 5 of the Act were attracted and a notice dated 8/6/1988 had been sent to the respondent asking for his explanation. It is wrong to infer malafides because of the passing of an order of suspension. While the single judge had mentioned about the order of suspension being passed and set aside, the appellants in this appeal have placed on record an order dated 14/1/1991 passed by this court in special leave petition of the Bombay High Court in favor of the respondent herein. Therefore, the aforesaid order seems to suggest that the final suspension order had lapsed, and with regard to the second suspension order, this court observed that the same should not have been interfered by the High Court, and it was by order of this court that the suspension of the respondent was revived. On the facts of this case, we are not satisfied that the appellant had acted in the malafide manner, and we are constrained to observe that the observations made by the High Court with regard to the malafides were wholly unjustified and without any basis. In fact, the question of malafides in a case like the present is not at all relevant. If the complaint which is made is correct and an offense had been committed which will have to be established in a court of law, it is of no consequence that the complainant was a person who was inimical or that he was guilty of malafides. If the ingredients which establish the commission of the offense of mistaken conduct exist, then the prosecution cannot fail merely because there was an animus of the complainant or the prosecution against the accused. Allegations of malafides may be relevant while judging the correctness of the allegations or while examining the evidence, but the more fact that the complainant is guilty of malafides would be no ground for quashing the prosecution. In the instant case, specific averments of facts have been made whereby it was alleged that the respondent had disproportionately large assets. Malafide intention of the appellant in launching prosecution against the respondent with a view to punish him cannot be a reason from preventing the court of competent jurisdiction from examining the evidence which may be led before it for coming to the conclusion whether an offense has been committed or not. Allegations of malafide were also made in a case against the informer. It was held by this court that when an information is lodged at the police station and an offense is registered, then the malafides of the information would be of secondary importance. It is the material collected during the investigation and evidence led in court which decides the fate of the accused person. The allegations of malafides against the informant are of no consequence and cannot by itself be the basis for quashing the proceedings. This court has consistently taken the view that the court should not, except in extraordinary circumstances, exercise its jurisdiction under section 482 of the Criminal Procedure Code so as to quash the prosecution proceedings after they have been launched. In a similar case, it was inter alia observed that we also give a notice of caution to the effect that the power of quashing a criminal proceeding should be exercised very sparingly and with circumspection, and that too in the rarest of the rare cases that the court will not be justified in embarking upon an inquiry as to the reliability or genuineness or otherwise of the allegations made in the first information report or the complaint, and the extraordinary or inherent power do not confer an arbitrary jurisdiction on the court to act according to its whim or caprice. The position of law in this regard has been very succinctly stated in the above said case that at the stage of quashing a first information report or complaint, the High Court is not justified in embarking upon an inquiry as to the probability, reliability, or genuineness of the allegations made therein. This precisely what has been done by the learned judge in the present case. The first information report having been lodged, the government of Maharashtra having accorded sanction, and thereafter the charge having been filed, there was absolutely no justification for the High Court to have stopped the normal procedure of the trial being allowed to continue. It cannot be presumed that there was no application of mind when the first information report was prepared and the sanction of the government obtained. The allegations as made in the first information report and the order granting sanction, if true, would clearly establish that the respondent was rightly prosecuted and was guilty of criminal misconduct. The truthfulness of the allegations and the establishment of the guilt can only take place when the trial proceeds without any interruption. There was no justification for the High Court to have exercised its jurisdiction under Article 227 of Criminal Procedure Code in quashing the prosecution. For the above said reasons, the appeals are allowed and the judgment of the High Court is set aside. Stop.